Tim, thanks for joining me on my session here, Logistics Insurance Advisory on the gap. Tim, you're my go-to guy for Michigan exposure. And I wanted to take a little bit of time to talk about, things in Michigan that are going on that folks may not know about related to commercial insurance for transportation providers. So, Tim, why don't you maybe introduce yourself and a little bit about your firm?
Yeah, certainly. And first of all, thank you for having me, and appreciate the invitation to help out and talk about some of these things that are important to both your clients and mine. So I am a shareholder at the Dickey McCamey firm, and I'm the managing partner of the Michigan office. Dickey McCamey is a regional law firm with 20 offices in 11 states, mostly east of the Mississippi, but we have an office in Denver and a location in Los Angeles as well. And so my focus as a 27 some odd year attorney is almost entirely been in no fault and in trucking specifically, representing a lot of different trucking companies in a lot of different capacities, either direct to the company through insurance, and handling all sorts of things, including even serving as we call transportation counsel for some of the smaller companies and what have you.
Thanks, Tim. We had talked many years ago about some of the changes with the no-fault law. And we don't want to go and take an exhaustive review of all those changes. We just want to focus on what we think is pertinent for commercial truckers in an interstate capacity. I think if you have an agent or an attorney or a firm based in Michigan, I think those issues are helpful. People know about them. I think where a lot of people get confused is if they're based elsewhere and they're running trucks through Michigan. So maybe just talk a little bit about that, Tim. What should an interstate carrier be concerned about related to their insurance coverage if they're running trucks through Michigan?
Yeah, so I guess the one thing to be concerned about, what they should know, is that that if you have a truck, specific vehicle that is in the state of Michigan for more than 30 days within a calendar year, then you are required by the Michigan No Fault Act to have a Michigan No Fault endorsement on that policy for that vehicle. And by that, it's not 30 days continuous, it's 30 days cumulative at any time throughout a calendar year. And you're required to have it. And it's actually a misdemeanor under the statute if you don't. And so it's important that if you think, you have a specific vehicle that's going to be even close to that 30-day mark, that you err on the safe side and get the Michigan endorsement.
So what does that endorsement do? I mean, I think PIP, or the acronym, it's personal injury protection, it came out of a personal lines coverage set and is morphed into being required on a commercial policy. And I think in Michigan, there's 3 options, Tim, for coverage?
Yeah, so they had a massive reform that took effect in June of 2019 that did a lot of things, but mainly geared towards, kind of, as you mentioned, towards the personal lines. But obviously it had a carryover effect to the commercial lines. And so for the PIP health coverage, Michigan had always had, since 1975, when no fault was first enacted, it always had unlimited PIP medical was required. And so the no fault reform did away with that in June of 2019. So unlimited coverage is still an option, but you can also purchase lesser amounts of either $250,000 or up to $500,000 in medical benefits.
So what that effectively does is it broadens the coverage set, for that client. And in many cases, clients may be taking a retention, so they're actually broadening their coverage or expanding their exposure. Is there any options that they might want to have related to their health plans or anything they want to do? Because PIP coverage is designed to be a first-party cover. So effectively, it would extend coverage to a driver, and drivers typically covered by workers' comp. So maybe is there anything else that a client would want to consider?
Right. So there is, a couple of things. One, they may not be too concerned on the PIP side of the coverages, and therefore maybe purchase a lower amount to be able to get a premium advantage there, because the way it works in Michigan is workers' compensation is an offset to PIP. So it's a kind of a back end around of saying work comp is primary. They don't say it's primary because the system is set up that they want the bills to be paid by an insurance company. They don't care which, but then ultimately work comp's the offset. And so that kind of incentivizes perhaps the lower coverage limits to be able to save on premium. There is also an option. You can opt out entirely of PIP coverage if you specifically have a health insurance coverage, which specifically covers collision injuries.
Okay. And I'm sure a lot of people aren't aware of that option. And for those that might not, health plans will typically carve out work-related accidents because the intent would be that be covered elsewhere, primarily workers' comp. So, okay. Anything else, Tim, that's relative to this no-fault law or some of the reforms that people might not be aware of again?
Yeah, I mean, I would just say overall that I think that it's good news for the competitive landscape of insurance in Michigan, and even more so on the commercial fleets. I think the commercial fleets should be able, all things being equal, right? Obviously, there's fluctuations in the insurance market, but that notwithstanding, just talking about pure expense of what Michigan no fault insurance may cost. I think there's benefits with this reform and the way they've structured it, because there was some requirements for rate reduction and underwriting criteria that were put into the reform, but those only applied to the personal lines. And so as a result, then the commercial side just enjoys all the benefits that should help reduce premiums overall. There were several things, I don't want to get too deep into the weeds, but several things that sort of took the socialism out of Michigan's no fault and made it a bit more sensible commercially. And so for the motor carrier, all things being equal, the insurance rates should be more competitive, and potentially, you should be able to have even more players in the market, so more options to choose from.
Okay. I think what's happened is that now that it's more defined, underwriters are more comfortable to write in Michigan, whereas there was a point where underwriting folks were avoiding Michigan exposure. So
that's precisely it. There were several things they did to give clarity as to what the exposure would be. Where before, I mean, there were times where just out of the blue, all of a sudden, you just bought a bad claim for doing nothing.
Yeah, we try to avoid those in the insurance game here, Tim. So now that law has been in place for over 2 years, what are you seeing as a result of that?
Yeah, so we figured in looking at it, what they did in enacting it is they restricted, the payments. So there's a payment schedule for the first time ever for no fault. No fault used to be the highest paying rate for the medical providers. And so now there's cost containment there. And so by design with that, the legislature shifted the onus to third party cases. The bodily injury claims, doing several things that increases exposure there, including for the first time since no fault was enacted, there's a possibility of medical liens if someone doesn't have unlimited medical benefits. But so we figured that, and there's a phase-in process for that, and under the No Fault Act, for both the cost containment and trickle through for when people may opt out of unlimited PIP. So I figured it would take a couple of years, before we start seeing kind of more pressure on the third party cases against the alleged at-fault drivers. But it seems to have occurred even sooner than I anticipated. And it seems in large part because it seems like the plaintiff attorneys can no longer make the money they used to be able to make on the first party cases. And so now that's putting the onus on the third party bodily injury claims, where the plaintiff attorneys are advertising far more aggressively now, it seems like, for trucking cases. And they seem more apt to take the risk to take them to trial, and seeing a lot of pressure that way, just to try to make up for what they apparently may have lost on the PIP side.
Well, that's unfortunate, but I think that's a common theme across the country. But I think that the fact that they might be pushing more to trial, that's concerning. Tim, I didn't. This is not meant to be an exhaustive review. I think what you've provided is very good. And just to summarize, Michigan has some unique no-fault statutes. If you're running a truck in Michigan collectively over a period of a year for more than 30 days, you're subject to those no-fault laws in Michigan. There are some provisions, again, if you're a Michigan carrier, related to the amount of money you can collect under the no-fault statute. And then what Tim had indicated is there's an increase in the amount of cases that he's seen going to trial as a result of this, because the attorneys aren't making as much money on the first party basis. So anything else to add, Tim, before we adjourn?
No, I think we've covered a lot there. So I think that those are the kind of the big things to think about.
Well, thank you, Tim. And I have an article that I'll post. That's a white paper, I should say, that Tim put together that has more detail. Thanks, Tim, for joining us, and I appreciate all your help.
You bet. Thank you. My pleasure.